Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg. One thing I do want to caution you about, and I'm not sure caution's the right word, but one thing I want to make you aware of is these arguments are being live streamed. And what that means for purposes of our discussion is once you've said it, it's said, and we can't pull it back. So it's going out over the internet just as you're speaking. So please think about what you're saying. Make sure you don't want to say anything that you shouldn't. And I'll leave it at that. Ms. Ashley, anything we need to take up before you call the first case?
No, Your Honor.
Not Ms. Ashley. All right, you may call the first case then.
Brittany Sharayah Lehmann versus Jerry Scott Wilson.
Good afternoon, Your Honors. I am attorney Wesley Clark, and I represent the appellant father, Dr. Jerry Scott Wilson. I would like to reserve 4 minutes of my time for rebuttal.
4 minutes.
Thank you. And Dr. Wilson and Ms. Lehmann are former unmarried romantic partners who share a child together. And this appeal arises from some very contested custody proceedings that resulted in a final order where my client received only 48 hours every other weekend of supervised parenting time. Now, that's a pretty extreme restricted schedule, and Tennessee's statutes and case law govern the limitations on trial courts in imposing such schedules. And there was an abuse of discretion in this case because the trial court failed to identify the legal standard governing these restricted supervised parenting plans, reached an illogical conclusion with respect to many of the findings in its order, and also based other findings on a clearly erroneous assessment of the evidence. So all of these things equal independently abuses of discretion. Now, when we look at the trial court's final order, it basically focuses on two major issues, and those are the allegations of physical abuse that both parties made against one another. Now, Ms. Lehmann's allegations were unsubstantiated by any other type of evidence. My client's allegations were not just allegations. They were substantiated by photographs of visible physical injuries that he sustained at Ms. Lehmann's hands. And beyond that, it's not just a credibility determination. It's also an admission. Ms. Lehmann admitted to hitting my client with a stroller. And that lines up with the photograph he introduced into evidence that's included in the principal brief showing a large welt protrusion on his shin. So this is not just about credibility, but that's what the trial court's order kind of reads like. Now, the other major cudgel that sort of beat my client throughout the order is his failure to exercise visitation. Now, if we look back at the record, the original visitation agreement was actually entered in the Chancery Court Orders of Protection cases. As soon as these parties broke up in April 2022, they both got ex parte orders against one another, which I'll add never went to final hearing. Months later, on August 1st, an agreement is entered that gives my client the right to see his child for the first time in months, and that's a Wednesday and Saturday visitation. Well, a few short weeks after that, in September, my client is accused of violating ambiguous orders from the Chancery Court. That ambiguous term is not my conclusion, it's the conclusion of this court, because this court heard my client's appeal from the convictions in those criminal contempt counts and entered an order in March of this year that overturned his convictions because the orders were ambiguous. And it was based on an alleged verbal statement and a text message. So there was no physical abuse allegation in that instance. So once that happens, my client loses his job. He's a physician, a position of high public trust, and once they find out he's been arrested, well, he has to find other employment. And so what does he do? He goes to the VA because he himself is a veteran, and he's able to secure immediate alternative employment through the VA in Miami. And he also immediately seeks relief from the visitation schedule with the juvenile court. Now, on September 2nd, he had filed a petition requesting a modification of the temporary parenting arrangement. On September 29th, 22, Ms. Lehmann filed a response where she argued, among other things, that he should make his request in Chancery Court. Well, so on October 20th, my client files a request in Chancery Court. And then 11 days later, Ms. Lehmann, her response says that, nope, you should go to juvenile court. So he's really getting a procedural runaround. And Magistrate Wright...
While you mentioned procedure, let me ask you a question. After there was a ruling on this matter that's on appeal, your client, he was still represented at the time, filed a pro se request for review and reconsideration of setting aside the final ruling, which we construe to be a motion to alter or amend. And my review of the record is that has never been ruled on. Does that mean we don't have a final judgment in this case?
Your Honor,
I think his attorney at the time in the trial court withdrew soon after that motion was filed, and but it was never ruled upon.
Your Honor, I'm sorry.
Are you aware of that?
I'm aware that that motion was filed, yes.
Are you aware it was never ruled upon?
Yes, I'm aware that many motions sit in that juvenile court file that have not been ruled on, and that is one of them. Our position with respect to that motion is that the trial court, by failing to entertain or enter any rulings on this case, has implicitly denied that motion, and that in the interest of judicial economy, the court should hear this appeal, because both parties have fully briefed the issues, and the appeal is ripe for review.
Well, are you withdrawing that motion?
Yes.
You are withdrawing that?
Absolutely. I'll withdraw it right now, should the court allow me that grace. And procedurally, that going back to the visitation, my client tried to get that modified, the Wednesdays. They didn't work for his schedule. The record showed that he spoke with mother about that. He attempted to modify it, and at the one opportunity the court had in March of 23 to entertain that motion, there's no explanation for why it wasn't heard. So we are left with the result at trial where every single factor that could possibly relate to visitation is held against Dr. Wilson because he failed to visit with his child. And this failure was not his own doing. And again, it's not based on the applicable statutes for visitation, for best interest, for restrictions and plans. What the court has to do is find, after a hearing, that visitation is likely to endanger the child's physical or emotional health. There's no such finding in this case. Even if the court's finding remains undisturbed concerning physical abuse, that alleged incident happened prior to the initiation of proceedings and had no apparent impact on future visitations with the child. The court found that the child was emotionally abused by observing this physical altercation between mom and dad. And if we look at the constellation of case law cited in my principal brief from Duffer, Pizzio, Levenhagen, Radabaugh, Spiegel, all these cases show that at its core, these restrictions have to be based on a finding that there's a danger of harm to the child for the exercise of unsupervised visitation. And then the statute requires that supervision be limited to the amount of time necessary to, protect the child in the future. And the court not only didn't identify the standard, but it also just conducted no analysis and made no findings which could possibly satisfy the standard. And the one case cited by Mother in her brief as applicable here that could justify such an award, In Re John B. It's cited, I think, about 5 times. In that case, the father had been found to have engaged in a pattern of emotional abuse, a campaign of emotional abuse against the mother that involved the child directly, telling the child to argue with and hit mother because that was God's rule. So also that father was accused of violating court orders, unauthorized pickup of child, involvement in social media harassment, where a former girlfriend testified that she created fake social media accounts to harass mother. So that, again, is in line with our analysis of the body of case law, that the harm justifying any kind of supervised visitation must be based on the harm to the child that would arise from this exercise of visitation in the future. So there's simply no justification in this court's precedent that could justify what happened to my client with respect to this visitation arrangement. And beyond that, we have the issue of attorney's fees, which is admitted to be an issue that should be remanded, at least in terms of having a hearing. But we would also show that because mother should not prevail in this appeal and the custody order should be substantially modified, that no attorney's fees at all are appropriate for mother. Likewise, my client has had to go through now 2 appeals to challenge orders from the court's custody arrangements that are invalid and deprive him of his parental rights without due process. And he should be entitled to attorney's fees on this appeal.
Thank you.
Good afternoon, Your Honors. May it please the court, I'm Jeffrey Payne of the Rutherford County Bar, and I represent the appellee mother, Brittany Lehmann. There are 2 important things about the appellant father in this case, Mr. Wilson, that I would like to focus on because they're so heavily intertwined with the issues and themes of this case. First, as the trial court found, father is lacking in credibility. And second, as the trial court also found, father is abusive. He physically abused mother on no less than 3 occasions, and further, he emotionally abused their child, who is the subject of this case. Starting off with father's credibility problem, his testimony was rife with evasiveness and inconsistencies. Regarding whether he lived in Tennessee or Florida, his position on what should be a simple question shifted regularly depending on what he perceived to be most advantageous to him. This was apparent right from the start as his trial counsel posited in her opening statement that father resided in Tennessee. This was, of course, to his advantage at the time because at the time of trial, he was seeking parenting time with the child. But the trial court had to interrupt father's trial counsel to point out a letter that father had sent to the trial court just a few months prior, wherein he claimed to be a resident of Florida. When he wrote that letter, he was seeking a postponement of the hearing on his attorney's motion to withdraw. So at that point, it was to his advantage to be a resident of Florida. These inconsistencies and father's evasiveness continued on into his testimony throughout this case. He was inconsistent and contradictory about which jobs he held and when he held them. He was inconsistent and evasive about the type of work that was available to him and where such work could be found. He was inconsistent and evasive about his reasoning for living and working in Florida in the first place. At various points in his testimony, he stated he went to Florida just to get away from the drama, that his arrest for violation of the order of protection and the issues he was having with my client and his lack of visitation. It was just too much drama for him, so he decided to go to Florida to get away from it all. But then at other times, he stated that the reason he went to Florida, the only reason he went to Florida was because that was the only place he could obtain an income. But then, to add another layer to it, contradicting all of that, he claimed at trial that if he was awarded the parenting time he sought, then he could simply leave Florida behind and begin residing and working in Tennessee full-time at a moment's notice. And this is where his story really started to fall apart, because the trial court very astutely pointed out the fallacy in his reasoning here. If it was really true that he could do that all along, then why hasn't he done it already? In the 8 or so months leading up to trial, father only exercised 6 out of a possible 37 visits with the child. And the reason for all these missed visits, according to him, is because his parenting time conflicted with his work schedule. So, getting to the crux of the matter, the trial court asked father, if you could drop everything in Florida immediately and begin your own psychiatry practice here in Tennessee, where you could set your own hours, why haven't you done that already? Why did you miss all of that visitation if it was within your power to exercise it? And to this, father had no cogent answer. So despite his arguments to the contrary, father has failed to establish the clear and convincing evidence that is necessary to contradict the trial court's finding that he was not a credible witness. Next, as to my second major issue regarding father's abusiveness, he was verbally abusive of mother, demeaning her in front of the child and other witnesses. He was also physically abusive of mother. He started out small. He would intimidate her, he would push boundaries, he would create these awkward, annoying situations, but all of this escalated over time, and after the birth of the child, that's when we started to see the manifesting of this actual physical abuse. In the first instance of physical abuse testified to by mother, he punched her in the throat and then proceeded, because he was intoxicated, to pass out on the bathroom floor, where he was discovered and photographed the next morning. In another instance of physical abuse, he inexplicably grabbed her by the throat, threw her to the ground, then picked her up, pushed her over a couch, and smashed blueberries in her face. And in a final incident of physical abuse, he attacked mother as she tried to leave his home with their child. Again, he grabbed her by the throat, this time choking her, and in a really strange manner of physical assault, he proceeded to shove his fingers in her ears and nose. This physical assault continued as mother attempted to flee, carrying the child while father was assaulting her the entire time. The party's child was present for all of this abuse, and the trial court found that this constituted emotional abuse of the child. So, moving on to another important issue that I wanted to address, that having to do with something that has come up throughout the briefing in this matter, and what this deals with is father's lack of any real effort to modify the temporary parenting schedule that was in place during the pendency of this case. All throughout his briefing, father contends that he was somehow deprived of the right to be heard regarding the temporary parenting schedule that was in place while this case was being litigated. Now, this is important not just as a procedural matter, but because father appears to argue that his failure to exercise the visitation that he was awarded only occurred because the trial court refused to modify the parenting schedule to comport with his work schedule. However, none of this is actually true. At various points in his briefing, he claimed, without any citation to the record, that the trial court refused to entertain his request to modify the parenting schedule or conduct an evidentiary hearing on March 3rd, 2023. That's just one instance. And I point this out because this is a large record. This is one of the largest records I've encountered on an appeal. And it's very easy to get lost in some of the details, and I think this is one of them where it's a mischaracterization of what's actually in the record. The reason there's no citations to the record in the briefing regarding this March 3rd, 2023 hearing that never took place is because the record is silent as to what became of that hearing. The record does show that there was a hearing scheduled on that date, but there is no indication of why it wasn't actually held. And there's other instances too. Father also claimed to have engaged in a relentless effort to obtain visitation rights. But the record clearly shows that each time he initiated an effort to modify his visitation, he did relent and he did abandon that effort every single time. Father cites to several portions of the record to support this relentlessness assertion, but once you actually analyze the record, and I've done that in my briefing and I'll go through it briefly here, once you actually put this under scrutiny, they all turn out to be nothing burgers. First, there was this motion that was filed in the juvenile court on May 18th, 2022. That motion was later stricken from the docket on August 8th, 2022, and never refiled. Second, there was a pro se petition that the father filed with the juvenile court on September the 6th, 2022. And in that pro se petition, he did request to have a modification of his visitation. However, before there was a hearing heard on this modification, he supplanted his pro se petition with an amended counter petition that was drafted by his attorney on January the 13th, 2023. And this new amended counter petition omitted any request for a visitation modification. Lastly, there was a motion filed in the Chancery Court on October the 20th, 2022 that was nullified and rendered mute by the transfer of jurisdiction to the juvenile court. So what we have here is a case that went on for many months. We had nearly a year buildup of visitation and trial prep and getting things ready, and there was some confusion as far as the transfer of jurisdiction, but nobody was trying to hide the ball here. The initial thing was that whenever the order of protection was filed in the Chancery Court made a visitation ruling. While that ruling was in effect, and until the Chancery Court relinquished that jurisdiction, then the jurisdiction remained within the Chancery Court. So it was up to the juvenile court couldn't make a ruling and by its own order until the Chancery Court relented that jurisdiction and released the case back over to the juvenile court to make those rulings. So nobody was hiding the ball here. Nobody was trying to deprive the father of his rights. What actually happened was he just never filed the right motion in the right place and actively pursued it. And he points to nowhere in the record where he actually did that, where he actually filed it, where he actually had a hearing, where somebody put up a roadblock in his way to deny him the due process he's due. That did not happen in this case. In his reply brief, Father goes even further to assert that the juvenile court explicitly declined to hear his request to modify the parenting schedule in one instance. But here again, it's a mischaracterization of what actually happened in the record. The juvenile court never told Father, you can't have a hearing on this issue. That never happened. Instead, what the juvenile court did was, at that time, jurisdiction still lay in the Chancery Court. So the juvenile court told the father, if you want to have a modification of the parenting schedule that was ordered by the Chancery Court, then you have to go to the Chancery Court. And that's where the jurisdiction will stay until they release the jurisdiction over to us. And that's the way it played out. And the fact that Father never took the appropriate action in either court to modify the visitation is nobody's fault but his own. So, as you can see, Father had every opportunity to seek a hearing on modification of the temporary parenting plan, and the only reason he did not have such a hearing is because he never properly sought one, even going so far as to strike his own motion where he sought this type of relief. So therefore, this assertion that the trial court may have somehow sought to interfere with his right to be heard on visitation, it just lacks all credulity, and the record is completely devoid of any support of this contention. The only portion of the record that father could cite to in his briefing to show his effort to modify the parenting schedule was an exhibit that consisted of an email that he, acting pro se, sent to mother's counsel. And regardless of father's layperson understanding of the law, sending an email to opposing counsel is not the proper way to be heard on such matters. So, as my time is winding down, lastly, I'd like to address the issue of attorney's fees on appeal. This is the only issue that mother has raised on appeal. Both parties have requested that they be awarded attorney's fees on appeal. And considering the relevant factors laid out in Ellis, I think these factors favor mother. Her ability to pay fees is much less than father. As evidenced by the child support worksheet in the record, father's income is more than 6 times that of mother's. Mother has participated in this appellate process and at trial in good faith, and should she be successful on the issues that are before this court, it is our position that an award of attorney's fees would be appropriate in this manner. So in closing, we believe that the final results here were just and in the best interest of the party's minor child. And we ask that you affirm the trial court in all respects. So barring any questions, I believe that's all I have.
I see none. Thank you.
Thank you.
We have 4 minutes.
Thank you, Your Honor. And yeah, let's talk about what was omitted from the order, and that piece of evidence concerning request for additional time. There was another source of evidence. That was the testimony of the only grandparent to testify, Miss Reba Wilson, my client's mother, who was present for every single visitation exercised after the orders of protection dispute. And she testified that she had asked mother for additional time and mother declined. So the record speaks for itself on that March 3rd hearing. It was set. My client had motions that had been filed regarding modification of the visitation. They were never heard. And it's impossible to cite to something that never happened other than to see the hearing was set and that nothing happened. So the record speaks for itself there. And this issue about being confused about Tennessee and Florida, both of these parties maintained residences in both states. That was very clear. Mother enrolled the child in preschool in Florida. And somehow this was only held against my client. And again, the court made no effort to even explain why it disregarded my client's photographs of physical abuse, Ms. Lehmann's admission to physical abuse. And when we're talking about credibility, let's talk about the bank records that were admitted without objection into evidence. Ms. Lehmann...
Did you make a motion to alter or amend in regard to those findings you say were omitted?
No, Your Honor. I'm not saying that I'm not saying the court omitted them. I'm saying the court abused its, I guess I did say omitted. I'm saying the court abused its discretion in just absolutely disregarding those as evidence. The court simply disregarded them.
To the attention of the trial court.
Your Honor, I was not representing Dr. Wilson at that time. Either way, such a motion may have been prudent, but as I understand, is not required in order to raise the issue.
Not required, but you also then had a review by the, you had the magistrate judge hear the matter, and then you had the juvenile court judge hear the matter. So was this matter brought to anyone's attention?
Your Honor, the juvenile court review was not de novo. This was after the statute came into effect. The court just reviewed a transcript-less request for review that did not contain the full panoply of issues that are raised in this appeal.
I understand that.
Yeah.
I'm just trying to ascertain if these errors were brought to the attention of, first of all, the trial court, and then to the juvenile court that reviewed the magistrate's finding.
Yes, many of these issues were brought to the juvenile court judge's attention. I can't say right now whether this specific issue was contained in that request for review, but as I understand it, the import of that is simply that the magistrate judge's order is the final order that we're now here appealing, so it's has no impact on the ability of my client to raise these issues now. And again,
I'm not saying that.
I understand, Your Honor.
I'm asking you what you did to bring this matter to the attention of the trier of fact.
The request for review was filed by another attorney who represented my client at that time that contained a lot of these arguments, but not all. So that's what I know about that. And I want to draw the court's attention to another little part of this order that exemplifies the issue here. My client was told not to go out golfing and jet setting. Nowhere in the entire record is there any evidence that my client even plays golf. The only place in the entire record where golfing is mentioned is where opposing counsel filed the Armbruster v. Armbruster case opinion. And in that opinion, the appellate court went into a lot of detail about the father's golfing habits. So this evidence that was apparently relied upon is illogical. This order is an absolute abuse of discretion.
Thank you. Thank you, counsel, for your argument. We will take this matter under advisement and attempt to render an opinion at the earliest possible time. You may be excused.
Thank you.
We call the next case.